every land buyer who promises installments should take notice of this case. It is very important that you are legally aware. The rules have changed on instalmental payment, and this is as recent as 2026. Imagine this. You finally find your dream plot of land in Abuja. The seller says it's 100 million naira. You negotiate. He agrees. You pay 40 million naira upfront. He even hands you possession. He allows you into possession of the land. You fence the land. You put up a gate. You start building. Everyone congratulates you. You proudly tell your friends and family, I am now a landowner in Abuja. Then business becomes slow. Money gets tight. You fail to pay the remaining 60 million. A few months later, the seller calls. I'm cancelling the transaction. You laugh. Impossible. I've already paid and I am already in possession. In fact, I've erected structures on that piece of land. The seller then does something you'd never imagined. He sells the same plot to someone else. He sells it to another person. Now you rush to court, believing that the law would protect you. How convenient. But then the Supreme Court delivers a judgment that shakes Nigeria's real estate industry, and every land buyer should pay attention. This is Law Stories Africa. We don't just explain the law, we explain the cases that can save you millions. We're here for you any day. The law before this decision, for many years, lawyers had advised clients that once there was a valid contract for the sale of land and that the purchaser had paid part of the purchase price, especially where possession had been given, the purchaser acquired an equitable interest in the land. Many believed that this equitable interest meant that the seller could no longer simply turn around and sell the property. This has been the law. Sell the property to another person. The buyer could often ask the court for specific performance of his obligations. That is an order compelling the seller to complete the transaction he started, the transaction he signed. So many buyers became comfortable. They pay something. They become very crafty. They pay. They take possession. Finishing payment later becomes a problem. Now, it became common practice in Nigeria. But then came Mustapha against Abubakar. The facts of this case were that Mustapha agreed to buy land from Mr. Abubakar. The purchase price was agreed. They agreed, they finalized, and Mustapha paid only part of the money. He was even allowed into possession of the property. He was allowed. Balance, you may ask. It remained unpaid for a lot of years. The seller gave him additional time beyond what was agreed. Mustapha still didn't pay. And naturally, a dispute arose. The buyer went to court, hoping that the law would compel the seller to command specific performance. After all, he had already paid something, probably had erected structure. He had already taken possession. Surely that counted for something. Yes, it does count for something. The case eventually, it reached the Supreme Court. As expected, the million naira question became obvious. The Supreme Court had a very important but powerful question. Can a buyer who pays part of the purchase price and then defaults force the seller to complete the transaction simply because he is already in possession of the property? Can he command specific performance through the courts? This question affects thousands of Nigerians because installmental payment of lands have become the norm, especially in estate lands. The Supreme Court made a final decision on this. The Supreme Court answered and said no. The court held that where purchasers makes only part payment and then fails to pay the balance within an agreed period of time, there is no completed sale in his favor. Do you follow? Even if he has taken possession. Interesting, right? Even if he has fenced the land. Beautiful. Even if he has started using it. Even if he's living on it, the seller's title remains superior. The buyer cannot insist that the court must compel the seller to transfer ownership. The court emphasized that specific performance is a discretionary remedy, not an automatic reward for paying a deposit. A purchaser who himself is in breach by failing to complete payment cannot ordinarily insist on equitable remedy. He who comes to equity must come with clean hands. Does this mean that the seller keeps your money? necessarily? Absolutely not. Not necessarily. This is where many people misunderstand the judgment. This is where a lot of questions have arisen. The Supreme Court's decision does not mean that the seller is free to keep both the land and every kobo paid. Absolutely not. Where the transaction fails because the buyer defaults, questions about refund of the part payment depend on the contract between the parties and the applicable principles of law. Many legal commentators have noted that where the seller resigns the contract and resells the land, the buyer's part payment may have to be refunded. However, this will be subject to the terms of the agreement and any lawful deductions. So, always read your contracts carefully, or you involve your lawyer to read them for you. What this means for every land buyer, you may ask. If you're buying a land by installments, what this means for you is don't assume possession equals ownership, because it doesn't. Don't assume fencing the property means you've become the legal owner, because it doesn't. Don't assume that paying 30%, paying 70% guarantees that the land is yours forever. Not if you default on the agreed part payment terms. Your greatest protection is not merely taking possession. Absolutely not. Your greatest protection is performing your own obligation of the contract. What this means for sellers, you may ask. This case is also speaking to you. If your buyer defaults, you cannot simply act recklessly. Follow the contract. Number 1, act lawfully. Number 2, where the agreement allows for rescission for default, follow that procedure. If litigation arises, remember that the court would examine the conduct of both parties. The 3 lessons I'd like every property buyer to take from this is: number 1, never agree to installmental payments unless you are reasonably sure that you can meet up the payment schedule. That is number 1. Number 2 lesson is that you should ensure your sale agreement clearly states what happens if either party defaults, and that you are comfortable with whatever that comes up to be. Number 3, don't rely on possession alone. Complete your payment, perfect your title, register your interests where necessary, and that is how you truly protect yourself. Thank you.